Okay, we are live.
Good evening, everyone, and welcome to the March edition of the Town of Kent Zoning Board of Appeals. Before we begin, I'd like everyone to please rise and recite the Pledge of Allegiance to the flag of our country. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. All right, very good. We only have, excuse me, one application before us here tonight, and that is the application of Mr. Gregory Almond and Todd Bania. Good evening, gentlemen.
Good evening.
Good evening, Mr. Smith. You are representing.
Good evening. Well, I am the older one of the Schilling-Smith duo. I am Schilling, and good evening to you, Mr. Chairman.
I see we're joined by Mr. Greenberg. Mr. Almond, Mr. Bania, you ready to proceed?
Yes. Can you hear me?
So why don't you tell us why you're here this evening?
I'd like to start, Mr. Chairman. Thank you for having us. As you stated, the applicants are Greg Almond and Todd Bania, and they are in attendance remotely this evening. Also tonight is Joel Greenberg, who is a licensed architect, and he is here as well. We were hoping to have 20 years at the meeting as well. He would have come physically. He wasn't capable of coming remotely. But it's important that the record show that Nicholas Spinzala has been on the site as a tenant for some 20 years and a tenant of my clients since 2012.
Nicholas is here with me. Nicholas is here with me.
Okay.
So he's able to.
Okay, good. Well,
Yeah, he's here.
okay, I didn't see his name. Well, Nicholas, thanks for coming. The property is 287 Golf Ridge Road. It's about 5.5 acres. The main house is a 3-bedroom house. The matching cottage is a 1-bedroom house. It has a shared well and a private septic. The tax map number is 31-2-14, and the tax map includes both the structures. What we're seeking, members of the board, is an interpretation, and the interpretation is that the cottage is a legally predated use. And a legally predated use is protected by the Constitution of the United States, the Constitution of the State of New York, of the town law, and of your Kent Town Code. It protects uses that were established before your code was enacted. And in this case, your code was enacted in 1938. In support of our request for an interpretation, we've scoured as much as we can, and we found a newspaper article, which is part of your record. And it shows that the predecessor in title, far before, in 1929, was enjoying her new house at the site in question. It's a 1929 newspaper article. So we hope we established the date of the main house being built through that newspaper article. Next, we'll have Joel Greenberg talk about his report. He's a licensed architect. He will state at some point a little bit down the road that he believes, based on circumstances, he's going to tell you that it was built at or about the same time. We have tried, after the establishment of the dates, to give you the continuity that you want. For example, we gave you an email from a person whose name was Walsh. She was a neighbor of the property, and her knowledge goes back to the 40s, where she says there was a cottage there in the 40s. And she also says she believed it was there as part of the original building. we attached an affidavit of a person named Marcus who owned the property from the 50s, the late 50s, all the way to 2012. And Mr. Marcus said that all along there was a cottage there, that he rented it, and that he believed, being the owner for 50 years, that the cottage and the house were built at the same time. We also attached for your review a home inspection. The home inspection was in 2012 when my clients purchased the property. He said that that cottage was built at least 60 years before, in 2012, which gets us to the 40s, the late 40s or the early 50s. I've attached assessment cards for your review, some of them old, some of them somewhat new, all designated this property as a residential multifamily. And in my opinion, respectfully, that's the substantial evidence we have to show in order to meet our threshold this evening. I submitted to you a memorandum of law, and the memorandum of law stated that these codes are getting very old, and it's hard to get someone, in my case, 83 years ago when your code was enacted, and 93 years ago when we believe the use was established. It's impossible, if not improbable, to get people to give you information about that. But we were successful in scouring the area and finding people that could say, yes, that was there and it was built at the same time. So we know that a brief factual pattern. We know that the house was built in 28 or 29, 93 years ago. It was established by the newspaper article. The predecessor in title in that case was a person named Burdette. And the newspaper article, which is again is part of your record, saying she was enjoying her new house. And this was a person who is in my client's chain of title. So if we start with that premise, we know that the use was continuous all the way to present. My clients purchased in 2012. When they purchased it, there were no violations stated. There was a tenant on the site who happens to be here with us this evening. Adjustments were made for rentals. Adjustments were made for the security. My client believed that this was a legal use. The tenant was in place. And one of the things that I'm sorry about is if you didn't get to make a site inspection, I hope you know that this isn't a shed converted. This is a formidable, beautiful home. A one-bedroom, identical, if you will, to the one that was built right next to it. And so it's not something where we're stretching. This is a beautiful home, shared well, its own septic. And again, my client bought believing that it was legal. 2021, we're served with a violation, and the violation advises my client to go get a demolition permit and knock it down. And of course, in my mind, that would be a terrible waste and not justified under the circumstances presented herein. On the law, I gave you a memorandum of law that talks about the United States Constitution and the New York State Constitution and the town law and the Kent town law. And it starts with this: an ordinance cannot prohibit a use to end if the property has been dedicated at the time of the enactment of the ordinance. And that's exactly the case here. If you buy into that newspaper article and you buy into what Mr. Greenberg is going to tell you, this is exactly a legally predated use. And we provided that through the series of information that I've already said and stated to you. What I want you to know is, and again, this appears in the memorandum of law, that because the standards are so hard to achieve, because most of the codes in New York are so dated, the burden has been reduced. And what we have to show substantively is that it's more probable than not than it was created prior to code and the use has been continuous. The latest court in the appellate division called the burden that my clients and I had before you, an insurmountable benchmark, because it's so hard to find live witnesses from 83 and 93 years ago. The likelihood of personal knowledge really is remote under these circumstances. But we do think we met our burden. And again, the newspaper established the debt was the predecessor. 2829, we established the house, was built. Mr. Greenberg's affidavit and his work will opine that the cottage was built at about the same time. And at this time, I'd like to yield it to Joel to discuss that issue.
Yes, good evening, Mr. Chairman and members of the board. As you can see, is it okay if I go on to share screen so I can show you all the pictures?
Yeah, go ahead, Joel.
It's okay. I think it's okay.
Okay, there you go. All right, starting with the top left, that is the main house, as you can see. And then the section picture to the right of that is also the main house. And the two bottom pictures are also the main house. And you can see the siding, you can see the design at the bottom of the siding. And then if you look at the pictures on the two right-hand pictures, the upper and below. Can you see the pictures?
Yes.
Oh, good. Okay. And the upper picture on the far right-hand side shows the front of the cottage, and the picture on the bottom, again, very clearly shows the type of siding, which you can see is a perfect match to what the main house has. That's number one. Number two, the foundation on both houses is beautiful stone foundations. Again, if you look at both the main house and the cottage, you'll see that they're identical. Inspection of the interior also shows that the wood paneling is similar. Even the doors are similar. So there's so much similarity on this. So that let's assuming that the main house was built in the late 20s, it would seem to me that there's no question in my mind that architecturally that the cottage was built probably around the same time, or certainly within a couple of no more than a couple of years difference. Again, that is such a unique siding. I mean, I've been in this area for over 50 years, and I've never seen anything quite as unique as this in any houses that we've seen or inspected or built. So it's my conclusion. I think you have a copy of my report, which is dated February 24th, that I definitely conclude that these houses were built. The first house, obviously, from the newspaper article, was built probably in 1928. And the cottage, again, was probably built within a year or so, but not much more than a year or so difference. Again, the similarities are just so overwhelming for me to indicate or to think that this house was built in the 40s, the 50s, the 60s. And I think some of the previous owners have indicated at least they go back at least certainly to the 40s. But I conclude that the cottage was built within a very short time period after the main house. And I'll answer any questions if you have for myself or for Bill.
Maybe I could just finish up, Joel, before, if you don't mind.
No, go right ahead.
So we've got the establishment of the date of building. Mr. Greenberg said the date of the cottage was shortly thereafter. And the continuity that I have to show is based on all the affidavits that followed. Carrie Walsh, a neighbor, said that she knew the cottage was there back in the 40s and it was built at the same time as the house. A very important witness that we found, he was the owner of the subject house from the late 50s all the way to 2012. And he said it was his knowledge that it was built at the same time, and he used it as a guest cottage and as a rental. The house inspector gets us into the 50s and the 60s, where he said it was clearly around that, before that time when it was built. And so the present owners carry us to present day, where the continuity is established as a matter of law, and all the way to present time of today's date. So in conclusion, I think we've established the date of the building of the house Mr. Greenberg has established the building of the Comet Cottage to be somewhat simultaneous or shortly thereafter. Neighbor Walsh put it in the 50s, Marcus put it in the 50s and the 60s. Neighbor Walsh in the 40s. Each one of them said it was their belief that it was built at the same time. And I think Marcus's affidavit is very important. He was in that house for 55 years and he said it was built at the same time. It was his understanding. And then we get to present day. My clients have used it from 2012 to present. So respectfully, I hope you agree that we've met our burden. Evidence is of firsthand knowledge is very difficult, but I think we've done enough to meet our burden. It's clearly it was set up before your code. Clearly it's been continuous. And I believe a pre-existing non-conforming use has been met as a matter of law and has a constitutional right to continue. Hey, Frank.
Okay, thank you. Anyone else? Okay. You know, there's no doubt in my mind that that something, a structure did exist. Okay, what I don't know what it was originally intended to be from the records that I looked at. I know that it has morphed over the years into a rental apartment, cottage, whatever you want to call it. It has morphed into a living quarters, but I'm not sure that I'm sold on the original intent of this cottage / structure. With that, I'm going to open it up to members of the board for commentary.
All right, well, I'll go first if that's okay, Mr. Chairman. Can everybody hear me okay?
Yes.
Okay. So I agree the house was built in 1929. I mean, I think we've, definitely proven that or given it solid a case that it was. I have to base on the records. So hearsay is good. And of course, having somebody who lived there for 50 years is also good. But when I look like the assessor's records and those kind of put the garage being built from what I'm seeing are tracking from like in the 40s, very early, like 1941. And on the assessor's card, it says here that it was a 2-car garage with quarters, no heat, no water. And so that kind of leads me to believe that it was a garage. It did have some maybe like guest quarters or quarters up on top, but not to the point of being a separate residence. And then if you look further, as the newer owner you mentioned had it, in the 80s, I can see where, Bruce Marcus, the prior owner, he did some substantial upgrades in there. There was electric installed. The 200 amp electric was done. Again, all in the 80s. So I can't find enough documented proof from the records we have that substantiate that it was an actual fully functioning apartment recognized by the town and the owner.
Well, Bruce Marcus's affidavit says that he used it as a guest cottage and he owned it from the late 50s. So he didn't mention anything about modification. He told me, and it's in his affidavit, that he used it as a guest cottage and he used it as a rental on occasion. So, I mean, you can believe what Marcus says, or you can believe in all assessor's record, but we're putting a record before you that I think is more detailed and more perhaps accurate than the ones you're reading.
Let me ask, I'm just curious.
What is the...
Go ahead.
Yeah.
I didn't mean to cut you off.
I've lost.
Are you still there?
Bill, are you still there?
No, go ahead. I am. I thought I interrupted you.
Yeah.
I'll repeat what I said. The
Paul, can
person,
you stop the screen share?
I'm sorry.
Stop the screen share, please.
Yeah.
Oh,
There you go.
The two witnesses that we were able to track down all spoke about as it was. And I would have thought when I asked Marcus about it, he said the cottage was as it is and that he rented it occasionally and he used it as a guest house occasionally. I mean, we can argue about the scope of the use. We can argue about, well, maybe it merged from this to that. The point of the matter is it was living quarters when, in my mind, based on the testimony of Joel Greenberg and of the neighbor and the owner that testified via affidavit and email. And even the building inspector said this building is at least 60 years old. That gets us into the 40s. So
Right.
I don't know what the old assessment cards say, but I do know that everything that I've presented to you is consistent with a cottage for guests or for rental from the time that it was created in 29 all the way continuously till today.
Bill, can I add something?
Yes, please.
Also, again, just looking at it architecturally, I know that it was talked about electricity may have been done at a later date, but it certainly, you can see from the structure, if you go into the garage, you look at the ceiling joists and stuff like that, and you go into the actual unit itself, you can see the paneling. The paneling was not something that was done in the 40s, 50s, or 60s. It's obviously very similar in architectural style to what's in the main house. And while it may not have been a year-round use, it may not have been used year-round, but it's quite obvious that it was used when it was built as a residence, but it may have been maybe just for a 3-season house or something like that. But it's quite obvious just walking through the house and then going over to the main house. The similarities are just amazing, and that's why I concluded that it certainly was not built in the 40s, 50s, or 60s, but it was certainly built around the same time in the late 20s and early 30s. But again, just walking through the house, you'll get, I can assure you that you'll get the same feeling that I got. And again, that outside, the siding on the outside is something that you don't see today. In fact, as again, I've been in Putnam County almost all my life, and something like this, and 2 units right next to each other with the same type of siding, the same design, is extremely unusual. And this particular one, to be honest with you, again, I've been in this area for a long time, and I've never seen anything that like with that design at all, ever, in this entire county.
Well,
Mr. Chairman, and Ron, if I could say this, what we're going through now is exactly what the courts have described as an insurmountable burden. We cannot give you eyewitnesses. You can't provide eyewitnesses in opposition. All we can go on is what we had. And the court has reduced the burden of showing non-conforming uses because, let's face it, we're getting older and all these codes are in the 30s and 40s, and you're not going to find anybody alive to give you a descriptive account, an accurate account of what's going on. And, with all due respect to this board, I think we've met our burden. I mean, was it a 3-season? Was it a 4-season? When was all these things that we don't know the answers to and can't know the answers to because it took place so long ago. But I do think we've shown that there was a guest house that was created back in 28 or 30 or right around there. And it's been continuous. And I'll disagree with anyone who disagrees with that, because my conversations with the owner from the late 50s all the way was he rented this house. He couldn't have rented a house without electric or without water. It was a guest house. Again, he put his guests there. Whatever information you have, I respectfully state, is not as accurate as somebody who's living on the site during the time in question.
Look, I believe that somebody has been living there or using it on and off as rental for the last 50 years. That I agree with you on that. That's very plausible. It doesn't mean that it was legal all that time. And that's really what we've got to look at. In that 50 years that somebody was renting it, was it legal? And
Ron, if the code was enacted in 38, there was no prohibition to a cottage. It wasn't illegal at the time.
well,
Our benchmark is 1938.
what if that cottage was built in 1941, and it was a tool house with guest quarters on top?
I'm not familiar with the code in 38, but I didn't think I had to address it because our point is it was built prior to 38.
Well, the house was. We don't know if the garage was.
If all we have is Mr. Greenberg's testimony and the statement of the two witnesses who said it, and the one who lived there for 50 years.
So you're saying
that cottage and that.
All right, Bill, so you're saying everybody knows this was multifamily property.
Yes.
All right. So, Mr. Almond and Mr. Banya, can I ask you a question? Did you take a mortgage for this property?
Yes,
So, if your deed and your title search, can we see that? I mean, that specify that it was a two-family home you purchased or multifamily property?
my recollection is it did say multifamily.
Yes, my recollection too.
So I'm going to be honest. One thing that'll help me with your case is I'd like a copy of the original title search that you had. And not that I want to be nosy, but your mortgage would state whether it's single family or multifamily that you were purchasing.
Sure, not a problem.
I think that would help your case if we could view that.
Well, I agree with your desire to see the title search, Ron. I'm not sure. I do a lot of mortgage work, and mortgages aren't changed with regard to or different with regard to a single family or a family with an accessory apartment. But I'd be happy to get you our title search and our municipal search.
On the mortgage, doesn't it? Well, Bill, I thought on the mortgage, it would state whether it was a single family or multifamily in the description.
You mean in the Schedule A? No.
Yeah.
If it's a multifamily, like a 3 or 4 family, they will call what's an assignment of rent so that if the mortgagor doesn't pay his mortgage, they can go after the tenants for the rent, but not on a single family or on a single family with an accessory apartment. That generally doesn't happen. I can get you the information you're looking for in the hopes that there's something there, but
Yeah.
I can tell you that my clients verily believed, having seen a fully functioning apartment and an adjustment for rental credits and a no violation letter. I mean, this board's going to do what they're going to do, and I would respect whatever they do. But these gentlemen thought they were buying legal. They did not think for 1 minute that they were going to get served with a violation. This came as a complete surprise for them.
Believe that. And that's why I think it helps your case. If I can review those documents, at least it gives us all a better mindset of, was it what on their title search, did it come back as two family? Did they mortgage a two family or multifamily? And if, I think it helps your case.
Yeah, but Ron, I don't think there's going to be any distinction in the mortgage that was given to these applicants, to anybody else with a single family house, they don't make a distinction in my mind between those two things.
Well, nonetheless, a board member has made a request. Can you honor that request, please?
I can do my best. Yes.
Okay.
Yes.
Pending review of that information, I think we should hold off until next session to review the documents first, see if we can find more information to substantiate that. Yeah, again, what I'm looking at so far, I'm only seeing, tax records that say a one-family dwelling, a garage with quarters, no heat, no water. So I think-
Look, I'm sorry, Ron. I totally appreciate Mr. Greenberg's assessment and work, and I totally appreciate the affidavits that have been presented. However, as Mr. Smith said before, all we have to go on is what we have, okay? And what we have here is the assessor card that Ron previously mentioned, so I'm not going to get back into it. So we need to have some type of documentation, be it by title report or mortgage paperwork, somewhere that we need to see if the dwelling was indeed a single family or a multifamily. I mean, you're asking me to believe, or you're asking the board to believe the affidavit, which we certainly are. I mean, we have no reason not to doubt these individuals. But again, you have to appreciate what we have on file.
I want to just suggest, Mr. Chairman, that the problem is the timing of it all, and that the burden on like this is reduced. I will seek to get any documents that the board is requesting, including my report. We'll grab a copy of the mortgage of record and anything else this board would want as is your request. Can I ask a question? If the board denies this application, is it our burden to come out back to you for a use variance?
It is my understanding that if we deny this application, your only recourse would be to file an article procedure with the Supreme Court.
But I'm seeking an interpretation tonight.
Correct.
I'm not seeking a use
Oh,
variance.
that's right. I'm
A
sorry.
use variance is a separate cause of.
I apologize.
You don't owe me an apology.
Yeah.
Thank you.
So in answer to your question, I don't know that answer. I'm not, I would have to defer to Bill Walters. Bill, do you know that?
I'm going to take the easy way out. I mean, this is an interpretation. If he can't go for this, then he would have to go for a use. The only other alternative is that we'd have to seek our lawyer's advice on our end to see which way it goes. But
Right.
tonight he's here for an interpretation. If that's declined, then he would have to go for a use variance. And then if that's declined, then he would have to go for an Article 78.
All right, does any other board member have any commentary on this matter? Okay, so here's what I propose, gentlemen. Mr. Smith is going to work on providing the paperwork that Ron Hansen requested. We will hold this over until the April meeting. And if you need more time, we will certainly give that to you.
Okay.
Is that acceptable?
Yeah, the record should say I'm Schilling, not Smith. I don't want to put Frank with work that he doesn't know anything about.
I'm sorry, I'm seeing Frank Smith on the nameplate here.
Yeah, that's still filling space though.
It's me. And yes, Mr. Chairman, I understand what the board is looking for, and we'll do our best, my clients and I, to get it over to you.
Thank you. We appreciate it. Right now, it's going to be held over until the April meeting. If you need more time, please let us know.
Thank you for your courtesies.
Thank
Very
you for your time and thank you for listening to our
Yes.
situation.
No,
Thank you
absolutely.
very much.
And we'll see you in April.
Thank you. Thank you.
Good night.
All right. Good night.
Bye-bye.
Good night.
Okay, and Vera, do we have any minutes to approve this evening?
Yeah, you have both.
Try it again, Vera. Okay, Vera, we have both January and February minutes, correct?
Yes.
Okay. I've had a chance to review the January and February minutes, and I assume the other board members have. Do I have a motion to accept the minutes?
I'll make that motion.
Do I have a second? Brett, second. All in favor?
Aye.
Aye. Okay, is there anything else before the board? Okay, great. With that in mind, do I have a motion to adjourn? A motion to dismiss or close? Vote. Brett made the motion. Do I have a second?
I'll second.
Second. Brett made the motion. Joe Greco seconded the motion to close. All in favor?
Aye.
See you in April.
So long, everybody.
Bye.
Right.